Let me say this, that today the Ethics and Anti-Corruption Commission welcomes the judgment of the Anti-Corruption Court sitting in Milimani, where the court has found the former governor of Samburu guilty of various corruption offenses. These include conflict of interest, fraudulent acquisition of public property, all of them relating to a case where the convict, that is the former governor, traded with the county government of Samburu during his 2 terms as governor. The ruling delivered by the court today has served justice to the people of Samburu. It is a ruling that EACC finds significant in a number of ways. For instance, this is the first corruption case of a criminal nature that has come to its logical conclusion, even despite the attempt that the DPP made earlier during the proceedings to withdraw the case. It is the first corruption case of a criminal nature where the court has found the accused persons guilty. In this case, we have the former governor, Moses Lenokolal, the then county secretary, and the other senior county officials. Today, the court has rendered its ruling, and the sentencing will be done tomorrow. The other way in which this case is significant is that it sends a message to all public officers, both at the national and the county governments, that there are consequences when one betrays public trust. When we talk about conflict of interest, such as the one that the former governor has been found guilty of, it is important to remember that conflict of interest is the bedrock of most of the mega corruption scandals that the country is grappling with. Today, we have over 40 sitting and former governors that are facing this kind of cases involving conflict of interest, which cases are at various stages in the criminal justice system. We have some that are under investigations by the EACC. Those involving 2 governors have just been completed, and the files are on their way to the DPP recommending prosecution. We have other files still involving governors, part of the 40, that are pending review and a decision by the DPP on whether or not to prosecute. And then we have other cases, part of the 40, that are pending before the Anti-Corruption Court. The matters that were in court were 10 until sometimes 2 weeks ago, when one of the cases involving a sitting governor was withdrawn by the DPP. So we have 9. When you remove this one that has been concluded, we now have 8 governors, that is former and current, with the cases pending before the court. The court has also rendered itself on the issue of withdrawal of cases. EACC remains opposed to the withdrawal of corruption cases during the trial. And therefore, it is good that the earlier attempts to withdraw this particular one did not bear fruit. EACC sends a warning to public officials that are engaging in a conflict of interest at the county government and the national government to know that their day in court will come. Some may ask why this case has taken around 5 years. It is because of the institutional capacity that is available within the criminal justice sector. It means that if we can strengthen the critical agencies that are involved in the fight against corruption, that is the EACC, DPP, and the judiciary, so that we have more investigators, more prosecutors, and more magistrates. That means we can be able to handle more cases at the same time. So those with cases who are yet to be subjected to the court process should not think that they are off the hook. When their time comes, action will be taken. The last thing that I will mention in relation to today's case, or the ruling, is that EACC is no longer pursuing prosecution of offenders alone. Contemporaneous with the prosecution of suspects, EACC is filing civil suits where money has been lost and is seeking to recover that money and returning the same to the public. The case involving former Governor Moses Eleanor is one of those cases because in addition to the conviction that has taken place today, EACC has already obtained orders from the High Court, from Justice Maina, where the judge ordered the former governor to forfeit the monies paid to his company by the county government. That means that where public funds are used to make payments that are premised on irregular or illegal contracts, such as where there is conflict of interest, that money is recoverable in full, and the EACC appreciates the jurisprudence that is coming from our courts, that even if you did the work, such as it happened in this case, the money paid to you will be recovered in full if that contract was illegal, if it was given in conflict of interest or violation of the public procurement laws. Given that these cases involving top officials are largely revolving around the conflict of interest, this reminds us of the importance of the conflict of interest bill that was recently before the Senate. The National Assembly rejected the amendments that were proposed by the Senate, and the bill is now headed to the mediation committee that has equal members from both the National Assembly and the Senate. And the EACC urges the Parliament to consider passing the conflict of interest bill in its original form, because the amendments that were subsequently made have watered that bill down to the extent that if that bill was law today, then the conviction that has been secured here today would not have been secured. So we are seeking to have a strong conflict of interest law so that it can address the current problem where senior state officials, together with their families, are trading with the county government, with the national government, and as a result, public money getting lost. Finally, EACC has several other cases before the DPP and before the court. We confirm that all those cases have been investigated with the same standards that were used in the investigation of the case where the court has today rendered its decision. That is all, unless there is a question.
Just perhaps a follow-up. You mentioned that there's one that is on EACC intends to take action, just like on the Lennon case.
Remember, the mandate of the EACC is to investigate. So the moment we investigate, we forward the files to the DPP. But in respect to the particular question that you have asked, yes, it is true that on the 6th of August this year, the DPP withdrew the case against the current or the sitting governor of Tharaka Nithi, Muthomi Njuki. That has been withdrawn.
Maybe reasons to
Of course, it is not up to us to interpret, but the reasons that were given to court are related to insufficient evidence. The court was informed that the evidence on the record was no longer sufficient to warrant continuation of the case.
EACC contested the case being withdrawn against the Naukula. Do they intend to do the same thing against Njuki's case?
The matter is already over because, yes, before the court, EACC opposed the withdrawal, but the court gave a ruling allowing the withdrawal to take place. That was before the Embu law courts on the 6th of August. I think that is all.
Having diligently evaluated the entire evidence presented in this case, as well as the defense, and having considered the submission by all the parties, but the inevitable conclusion that the prosecutor proved the case against the accused person beyond reasonable doubt on the following charges. Accused person, you stand up. All the accused persons. For the first accused person, Moses Kasaine Lenakolal, I find you guilty, convict you for conflict of interest provision section 42.3 as read with section 48.1 of ASECA. That is per count number 3. For count 4, I find first accused person Moses Kasaina Klang and 11th accused person Nesbon Jack Washirandadi jointly guilty and convict each one of you for unlawful acquisition of public property, contrary to section 45(1). A as read with section 48(1) of ASECA. The amount is what I've calculated. Count 5, I find second accused person Stephen Siranga Letinina guilty for abuse of office, contrary to provision section 46, as read with 48(1) of ASECA. Count 7, I find that accused person, Danny. Who is Daniel Nakuo? You are Daniel Nakuo. I find you guilty and convict you for the abuse of office, contrary to section 46, as read with 48 of ASECA in count 6. Who is Josephine Namo Lenasalia? I find you guilty for abuse of office and convict you, contrary to provision of section 46, as read with 48 of ASECA. Ruben Lemunyeto, who is the other one? I find you guilty, convict you for abuse of office, contrary to provision 46, as read with 48 of ASECA. For count number 8. Linus Milton Lonol Genje. Milton, I find you guilty and convict you for abuse of office, contrary to provision of section 46, as read with 48 of ASECA. Paul Lomilgani. Paul, I find you guilty, convict you for abuse of office, contrary to provision of section 46, as read with 48 of ASECA. As per account number 10, Bernard Latarasi Lesumat. Bernard, I find you guilty, convict you for abuse of office, contrary to section 46, as read with section 48 of ASECA. Lillian Balanga, I find you guilty and convict you for